Hey everybody, Derek Christensen here. I'm an estate planning and probate attorney in Dallas, Texas, and today I wanted to talk to you about what happens if you die without a will in Texas. But before I do that, I wanted to let you know how to reach out to me. You can find me at my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me at my website, www.legionlawpllc.com. So with that, let's dive right in. This is a very common occurrence. Unfortunately, many people pass away without having some kind of estate plan in place. It is the most common situation where people are simply just not willing to think about their mortality. They don't want to address it, and sometimes it sneaks up on us. It happens, no judgment either way, but at the end of the day, we have to figure out what do we do if there is no will. Now, Texas has two laws on this issue. One, it will say, if there is a will, we will do whatever the will says. But if there is no will, then you must follow these very long lists of rules. It's called intestacy laws, but I call them the default laws of Texas. Now, these default laws are not very generous. They do not take anything into consideration. You must follow that law. Doesn't matter anything else. So if you have a great family relationship, or if you have a terrible one, if you have a complicated relationship with your brother who's stealing from you, but you're trying to help them out and you don't want to give them anything, but they should get at least something, but not everything. No, the intestacy laws do not care. The default laws will not care. It will say this person must receive X percentage of this estate. This type of property goes this way, and that's it. There is no question whatsoever. So if you are trying to split your assets up in a particular way, if you want to guarantee that asset split happens, you should really look at a will and or a trust. However, if you do not have a will or if you don't have a trust, you are going to be subject to those default laws, and again, they will apply certain ways. Default laws do not treat blended families correctly or well in Texas. And when I say blended families, think of the Brady Bunch. You have man and wife had kids with other men, man had kids with other wives or whatever, and they're a blended family of stepchildren, step-parents, right? In this situation, if you die without a will, oftentimes the stepmother's living situation will be controlled by the father's children. And just a bunch of other things will pop up that are not fun whatsoever. I guarantee if you are a blended family, you should strongly consider a will in Texas, because these laws were written back in the 1830s or 40s when we became independent, and those laws were written to prevent two situations. One, the ranch owner from going down to the saloon and throwing the deed on the table and gambling the children's inheritance away, right? They didn't want the drunk saloon owner to steal everything. And the second situation was that they were worried about these women coming in from the East Coast, marrying into cattle ranches, and then taking the cattle ranch from the children. So blended families are treated very differently, and it's not good. Trust me, if you're a blended family, do get a will, command form. But even if you're not in a blended family, still, you want to have a will, because even if you think that the spouse is going to get everything and the children in equal shares, if you don't have a will, probate is going to be slower. And again, probate is the way that we determine who's in charge of splitting everything up and how everything is split up. If you have a will, you will be on the faster, cheaper form of probate. It costs about $4,000, $5,000, takes 3 to 4 months to go through probate with a will. Without a will, it will cost $7,000, $8,000, and it will take 6 months before everything can get split up. So during that time, your children are waiting 6 months. They're hiring attorneys. They're having to do phone calls. They're trying to do all these kind of things. And having a will, even if you're not a blended family, puts you on that fast track to at least suffer only a little bit through the probate system, not much more than the blended family without a will. So that being said, if you're interested in avoiding probate entirely, then you would have a will, but you'd also have a trust, and that's for different videos I've already made. So you're welcome to check them all out. You're welcome to email me any kind of questions you have. I'd be more than happy to kind of explain what's going on. What will happen if you hypothetically passed away tomorrow without any kind of estate plan? Ask me anything. I'd be more than happy to answer. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com. Or you can find me on my website, where you can schedule a consultation directly onto my calendar for free, www.legionlawpllc.com. So with that, thanks for watching and have a great day.